All of us, based upon the fact that we are citizens of the state of Michigan as well as citizens of the United States, have this large bundle of rights.
The same rights that everybody experiences, and it belongs to the consumer as well.
When you come into the system, you actually get additional rights to protect you while you are receiving services within the system.
As a consumer of mental health services, you are entitled to rights. One right is the right to file a formal complaint when you feel your rights have been violated.
The dispute resolution process, that is the rights complaint, the rights investigation, the local rights appeal, and the state level appeal.
If your services are paid for by Medicaid, you have an additional set of rights. They give you the right to dispute an action taken by your service provider.
So you're a citizen and you have rights. You're a recipient of public mental health services and you have another bundle of rights. And when you are a Medicaid beneficiary, you have a third set of rights. It's in this bundle of rights under Medicaid where you have the right to a grievance and appeal process.
You have the right to file a formal grievance or appeal if you are not satisfied with your service. This formal grievance or appeal will be reviewed by a committee made up of consumers and healthcare providers. The grievance and appeal are separate from the rights complaint. All parts of the system work together to make sure you are heard. You file a rights complaint when you think someone has violated your civil rights or rights given to you by the mental health laws. An appeal is different than a rights complaint. You file an appeal when you don't agree with changes your service provider has made to your Medicaid-covered service.
An appeal is an appeal of an action which is a suspension, reduction, termination, or denial of a Medicaid-covered service.
A grievance is different than an appeal. You file a grievance when you are dissatisfied with some other aspect of your Medicaid-covered service, but no change in service has occurred.
A grievance is a statement of dissatisfaction with any other aspect of treatment or services.
If your grievance or appeal is also a potential rights violation, it will be forwarded to the Office of Recipient Rights for simultaneous investigation.
If you go to customer services, you file a grievance, and it's also a potential rights violation. Again, customer services or the other office will send a copy of that over to the rights office. They work hand in hand, but each office has a different function. There is no wrong door for filing either a grievance, appeal, or a rights complaint.
The appeal process can be confusing if you've never gone through it. It begins when the service provider takes an action. This could be a reduction, suspension, termination, or denial of your Medicaid-covered services. If a provider takes one of these actions, they are required to notify you in writing. If you disagree with the action, you may file a local appeal. You may also choose to request an administrative hearing with the Department of Community Health.
The consumer or the beneficiary appeals. Customer services will facilitate a panel that will involve a clinician at the same level as the clinician who reduced the intensity, probably a medical director who is familiar with the beneficiary's condition, who was not involved in the original decision.
The appeals panel will give you a chance to present evidence in support of your appeal. The panel will review whether or not the action was justified.
The consumer can be present, their legal representative can be present, and they'll review all the information and make a decision. So that's a local decision.
This entire process must take place within 45 days.
If there is an action taken against your Medicaid-covered service, for example, a suspension of the Medicaid-covered service or a reduction of the scope, intensity, duration of that Medicaid covered service, or it's entirely eliminated, you have the right within 45 days of receiving notice of this action to request a Medicaid hearing. That's a hearing that's conducted by the department's administrative tribunal.
It's not a formal process. It should be a comfortable process for people. The judges, I think, are very kind. They want to get the information. That's all they want, so they can make a fair decision. I think that it's a right that are given to the clients, and they should avail themselves of that.
If you do not agree with the state's findings, you can still appeal to the circuit court.
They may go directly to circuit court. That's always their option if they're not happy with the decision.
During this entire process, you can request that services continue until the appeal is resolved. But you may have to pay for your services if the appeals committee decides the action was appropriate. There is a similar process for grievances. A grievance is a dissatisfaction with some element of your Medicaid service that is not related to a change in service. An example might be that you don't get along with your doctor and would prefer to work with a different doctor.
A grievance is defined as dissatisfaction with any aspect of service delivery.
If you experience dissatisfaction with your Medicaid-related service, you may file a grievance at any time. Your health service provider will notify you that they have received your grievance and will assemble a group to resolve the grievance. The grievance must be resolved within 60 calendar days, at which time you will be notified of the committee's decision.
So exercising either the appeal or the grievance at the local CMH level does not eliminate your ability or your right to request a Medicaid fair hearing.
If you are not receiving services paid for by Medicaid, you have a local appeal process available to you and can ask the state to review the local committee's findings.
Non-Medicaid, we have a parallel process. You can file an appeal if there's a suspension, reduction, termination of your services or supports that are included in your plan of service, or if there's a denial of your request for services. You can file an appeal. You can also file a grievance if it's not about an action, if it's dissatisfaction or something. You can file a grievance. However, you have to exhaust, or you have to go through the local appeal process, and you're not entitled to a Medicaid fair hearing, an administrative hearing. However, the department has a process where you can request dispute resolution at the Department of Community Health level.
If someone is unhappy as a non-Medicaid person with a decision, they have a local appeal process that someone sits down with them and reviews it, and it can't be the person that was involved in the decision. They try to make it very fair. Well, I think they are very fair, so that they're really looking at the decision, because the point is to make certain that each client has a fair access and a fair decision made. So it's a good way to check on yourself and check on your agency.
The state tribunal is not the same as a court of law, and a hearing in front of the tribunal will look different.
What happens in a hearing is first judge introduces herself or himself. They go on the record. They swear people in. And in these cases, we ask the department or the PIHP to explain. Now, they should have, it's required, completed a hearing summary which describes what action they took, when they took it, why they took it, and then the documents that they use to support that. They may have witnesses there to support the documents, maybe doctors, psychologists, it depends on the hearing. That helps the judge get a feel of at least what the agency has done. Then they ask the client or the client's representative to respond to that and to present their own hearing. And the client will have an opportunity to question the department, to challenge the department.
There are other differences that make a hearing in front of a tribunal more friendly for a consumer.
The judge will make certain that there's nothing more to be added. Sometimes the judge will say, I don't have enough information. I may need another psychological profile. I may need another medical review. That is within their purview. They have the right to order that, and they do that often. Or the department will say, well, you know, the client didn't tell me this when we met. I would like to hold the record open. If you close that record, it's done. The hearing's done. No more information can be provided. But if you hold the record open, if the law judge allows the record to be held open, that means the hearing is not ended. The judge can allow in more evidence and more testimony. So if the judge believes that he or she does not have enough information, or if the client or the department said, well, you know, I didn't know that, I'd like an opportunity to provide that, that will happen. And they may go back on the record, the judge may recall people, or he or she may just take the written evidence and send it to both parties, allow both parties to respond to it, and make a decision without any further testimony. That is a call that the judge makes. Once that process is completed and the record is closed, it's done.
The Grievance and Appeals process exists to protect you and give you access to your treatment.
It's a wonderful process to avail them of those rights. That's why they're in the federal law, that's why they're in the regulations, and it's due process. It's basic constitutional law.
In addition to the rights you have as a consumer of mental health in Michigan, you have rights to disagree with treatment and treatment changes, and to have your disagreement heard.
They have a right to a hearing. They have a right to that notice that tells them how to access a hearing, and they have a right to know why the department decided to take the action that they took.
Though it may be confusing at first, there are people at the local and state level to help you the entire way through the process.
The process should be user-friendly, because that's the whole point of it, is to help the clients.